Hey everybody, Ryan Pacyga coming back at you again for day 3, my reactions to the Chauvin trial. And here's what's going on. Today, the big news was, and this is why I waited to put this up a little later than most mornings, I wanted to hear the arguments about whether third-degree murder charge should be reinstated in the Chauvin trial. And when the judge gathered the lawyers at 8:30 this morning, he wanted to give them an opportunity to argue about that and consider what are called motions in limine. This is before they bring the prospective jurors back out again. So this is not in the presence of the prospective jurors, and that's normal. So the arguments went like this. If you remember right, the Minnesota Supreme Court of Appeals in the Knorr decision held that third-degree murder can be focused at a single person, and they talked a little bit about what a depraved mind means, all right? And they upheld the conviction in Officer Knorr, all right? He was the guy that shot from the squad car past his partner in the squad car and killed Justine DeMond, who had called the police about a situation. And the argument there was that, well, it could have also endangered other people that were in their homes, on the sidewalks, running around in the neighborhood, what have you. But the Court of Appeals went a little further than that in that case and said, and it can even be targeted at a single person. All right, so the issue then became, well, given that ruling, when Judge Cahill threw out the third-degree murder charge back in the fall in this Chauvin case, whether or not the Court of Appeals' new decision is precedential and whether that forces him to put back in this third degree or whether that can be distinguished. So the lawyer, Eric Nelson, comes up first. He's the defense lawyer for Chauvin, and he argued that the single person rule, although that's in play, it really doesn't apply here, particularly to the facts of the situation. And Judge Cahill responded, and he said, the Court of Appeals didn't necessarily need to go that far in the Knorr decision, but they did. And so he was just pointing that out. I think he's still kind of irked by the language in the Knorr decision. That's just my read on it. I could be wrong, but nonetheless, it seemed to be that was his take. And so then what Eric Nelson did is he had to do is try to distinguish the facts in the Chauvin case from the Knorr case. And he brought up what a defense lawyer would bring up in that situation, that in Knorr, the gun's fired, and arguably that could endanger other people besides the person that he killed in that situation. Whereas here, Chauvin's knee is directly on Floyd's neck, and nobody else in the community or in that scene would have been endangered by Chauvin's action because it was directed particularly at Floyd's neck. And it's not like firing a gun where if you miss, you could maybe hit somebody else. So he did what he had to do to try to distinguish that. He also did some other things. He tried to bring up an ex post facto law, which means if a law is clarified now, it can't be retroactively applied because the defendant wouldn't be on notice of that at the time. And that was a weak argument. Now, I'm not criticizing him for making it. I didn't think that would hold any water, and sure enough, it didn't. He's just raising that, even though it was a weak argument, so that at some point, if he needs to appeal anything for his client, he's put everything on the table that could be appealed, because if you don't make the argument now for that, you waive it on appeal. So I understand why he did it. I didn't think it would hold any water, and sure enough, the judge quickly dismissed that. But again, he's doing what he can for his client in that situation. Nelson also brought up this Baxter case that the court has inherent authority, meaning its own authority, to deny when the prosecution wants to amend a complaint at the last minute. All right. And yeah, they do have inherent authority there. I also thought, I knew that argument wasn't going to go anywhere. And the reason for that is because the defense has been on notice a long time that the prosecution was trying to get third-degree murder. In fact, they had made it a complaint with that, and it was there, and Judge Cahill had thrown it out earlier. So this is not a situation where the prosecution was coming at the last minute with this newfangled theory about another crime being done. And so that wasn't going to fly. And sure enough, Cahill called that out as well. And I thought that was the right decision there. So then came the prosecution's, one of these special prosecutors. And I don't know if this guy is sitting in an office in Washington, D.C., because he's not a Minnesota guy, or whether he's sitting in an office here in Minnesota. But he's the guy that comes in on Zoom. He's not in the courtroom. And keeps calling my friend, meaning the lawyer on the other side. Listen, they ain't friends. All right. There's nothing friendly about these two. they've got different perspectives on this. And although they may be cordial with each other, believe me, buddy, you're not friends. Okay. So at any rate, he's pointing out the opposite sides of the argument, of course, and indicating that, the Court of Appeals ruling is precedential, and that this single person thing is in play, and all of these sorts of things, and does what he has to do to distinguish the law in that. And ultimately, the one thing that did catch my attention is Judge Cahill, who's been around a long time, says, well, wouldn't you agree that third-degree murder law in Minnesota is murky? And he goes, no, I wouldn't agree with that. Buddy, the third-degree murder law in Minnesota is murky as all hell. It is very murky. It's murky about depraved mind. The Court of Appeals decision and more even made it more murky because it really twisted things. So it's murky, buddy. Okay. Any lawyer will tell you that the third-degree murder law in Minnesota is murky. So I don't agree with him there. But nonetheless, what Judge Cahill did is he had an option. He could either try to distinguish this further and say, I can get around this Court of Appeals decision, or he did what he said he did, is he felt bound by the precedent. And even though the facts are distinguishable in Knorr and in the Chauvin case, he felt bound by that single person analysis that the Court of Appeals had said in Knorr, even if he disagrees with that decision. Unless and until the Supreme Court reverses that decision, Judge Cahill's bound by what the Court of Appeals is saying right now. So he did grant the motion. The third-degree murder charge in the Chauvin case is back in play. It is one of the charges, just like the second-degree charge and the manslaughter charge. It is back in play now. It reminds me of that old Aerosmith, that song that says, I'm back in the saddle again. Indeed, third-degree murder, back in the saddle again in the Chauvin case. So then the judge asked the defense lawyer, hey, your other remedy is to try to argue if you want a continuance, all right? I don't know if he would have been able to argue for that because he knew this third-degree murder charge was potentially in play for a long time again, at least when these appeals got going. But the defense lawyer didn't argue for it anyway. He's ready to go. I think he's thinking that the prosecution isn't as ready as they think they are for this trial. And I think he's trying to seize on that opportunity. He's ready to rock. So here we go. So what we have left is what could happen with this third-degree murder charge? Well, you can expect jurors to continue to be examined today. When the case goes forward and the jury's sworn in and all the testimony's done and the state rests, the other thing the judge might be able to do is distinguish it at that point in time and grant what's called a judgment of acquittal. If he does that, that would take the charge out of the jury's hands. If the judge says that there's not even enough of a debate for that charge to go to the jury because of the way he views the law, he could do that. And if he does that, guess what? The state can't appeal that decision. So the judge could do an end around this whole Court of Appeals decision anyway. I'm not saying he would do that, but is it possible? It could happen. We don't know. So what do we expect today? Well, more motions in limine, and we'll continue on with jury selection. You're going to see a lot of what you've already seen in jury selection, although each individual is unique. The same sort of things, though. Each side can still try to strike people for cause, which I made a video about yesterday. Each side can still has some peremptory challenges left, their own strikes that they're allotted. So that's going to happen, and we'll keep going with jury selection. So I told you, expect the unexpected. Here we are back now. Third-degree murder is back in the saddle, and we'll keep moving forward with the trial. I'm criminal defense attorney Ryan Pacyga. I hope this helped you, and I'll see you tomorrow.